Mngomezulu.
My Lord, firstly, my Lord, I wish to express my apology for my non-appearance due to the circumstance that I was not feeling well to come to court, my Lord.
Okay, fine.
Court pleases, my Lord, may I beg leave to hand over the heads of argument for in relation.
Yes, thank you.
Court pleases, my Lord, the heads of argument in relation to accused number 1 and 2, because that will actually even touch the movement of Mr. Mkhani in relation to accused number 2. They are structured in this manner, my Lord. Introduction, it deals with the gravamen of the objection or issues. My Lord, it has been submitted. We'll submit that the application by the state to re-examine Sergeant Mkhani on the evidence or on the document of an AVL does not find fairness and justice because he is not a competent expert in the field of the tracing and the tracking systems. Our heads of argument are structured as follows. Firstly, paragraph 2.1. There are two state witnesses which has testified about the escorting of Sergeant Mkhani and the late Sergeant Mabena to various places. Their oral evidence was not supported by AVL records, and as such, why would it be significant to re-examine Sergeant Mkhani differently from other witnesses who were escorting Sergeant Mkhani and the late, including the accused person? May I substantiate my argument in the following manner, my Lord? In this case, I would submit that the defense is relying on the submission made by the state in their heads of argument to the effect that the reason for the recalling or tendering this new evidence is based on the version of accused number 2. The case of the state, my Lord, is not founded on the version of accused number 2. This version is put to the witness to counter the evidence given orally by Sergeant Mkhani. And, my Lord, this is a documentary evidence which, by submission, was supposed to be discovered prior to the matter being set down for hearing and during the discovery of relevant documents. On paragraph 2.2, my Lord, it is contended that secondly, the nature of the AVL records requires an expert who will be able to explain the synopsis, functioning, and the recording of the AVL system. Thirdly, the state has not laid the basis of the AVL's report, and the state has not established the agent who tracked the motor vehicle or the movement of the Toyota Fortuner as from the 16th of June 2020 to the 27th of October 2020 and beyond. The role of an expert witness and the evaluation of the expert witness. An article was drawn from Tools and Trade. It's headed 3rd March 2021. The expression expert witness is ordinarily used to refer to a witness whose opinion and the reasons on which they are based are admissible in evidence in litigious, technical, and scientific nature, enables such witness to draw inference and form views in circumstances where a court or a tribunal is unable to do so reliably unless it receives an assistance or guidance from someone with expertise on the relevant subject matter or in that particular field. My Lord, it is further submitted that in case this proposition has been supported by R. versus Vilbro and another, 1957, Volume 3, SA 223, AD, page 228, from G to H. It was held that a party intending to call or calling a witness to give expert evidence of the kind discussed, he is required to furnish the other party with a summary of such witnesses' opinion and reasons thereof. In this case, my Lord, nothing has been furnished to the other party as contemplated by or as provided in the case of R. versus Vilbro. I would submit further that before we proceed, the state, after having discovered this document on the Friday, which it has already submitted, was not a reasonable time for the state to produce such a document or to discover such a document, and as such, there is no summary of such witness in leading his opinion of the records. In the case of Schneider NO versus Automobile Association and another, Judge Davis also referred the well-known South African textbook of the law of evidence, Zephyr, in Paces and Skien, the South African law of evidence at page 330, where the learned authors thereof, citing the English judgment of National Justice Campania, Nivera, South Africa versus Prudential Assurance Company Ltd, outlines the duties of an expert as follows. An expert evidence presented to the court should be and should be seen to be the independent product of the expert, uninfluenced as to the form or content by the exigencies of litigation. In this case, my Lord, I would submit with respect that Sergeant Mogano is not a neutral person in giving assistance on the evidence of these AVL recordings, on the basis that he is a team investigating this matter, and his conclusions will always be biased. May I further make a submission in terms of the above mentioned case? An expert witness should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters with his expertise. An expert witness should never assume the role of an advocate. An expert witness should state the facts or assumptions upon which his opinion is based. He should not omit to consider the material facts which could detract from the concluded opinion. An expert witness should make it clear when a particular question or issue falls outside his expertise. In the case of MTV versus MEC Health, the Pretoria High Court once again placed the issue of expert evidence firmly in the judicial spotlight. Focus was squarely placed on the requirement for expert witness to provide the court with an objective and unbiased opinion as possible based on their expertise. What is common cause between the parties? There is a common cause between the state and the defense that the evidence to be led is requires an expert evidence. Sergeant Mukhane is not an expert in the AVL system or recording or systems, my lord. They're supposed to be records. But for investigating team in the matter of Senzo Meyiwa under case number 636 of 10/2014, submissions by counsel for accused number 1 and 2, it is submitted with due respect that the evidence of the AVL recordings does not exist in vacuum, that the kind of expert evidence requires an expert who is not biased and does not have does have an independent and impartial conclusion and inferences. As discussed supra, the tracking agents must assist the court with expert opinion which may be admissible as evidence. The expert to which the state has not convincingly brought the evidence to which the state has not convincingly brought its case on the admissibility of confessions and of pointing out, it is my humble submission that the state case on the trial, within the trial, be argued and finalized after the testimony of Brigadier Gininda. There is no law available justifying the limitation of Section 35(1) of the Constitution and Section 35(5) of the Constitution for non-compliance with the provisions of Section 217, 1A and 217, 1B, Roman figure 2, respectively. The expert evidence of any nature in these proceedings may be utilized in the main trial, and in the event the above honorable court find in favor of the state by ruling on the admissibility of the alleged confessions and pointing out, the expert evidence causes an unreasonable delay in the finalization of this trial within the trial. In conclusion, even if an expert can be called therein, there is no likelihood to assist the court drawing inferences, a reasonable conclusion on the face of the produced or discovered document or copies of the AVL records, dental reports. Furthermore, when looking at the AVL reports, it does not stipulate exact places where the said vehicle went and stopped at. My Lord, this is the summary of the heads, which I would like to beg leave, my Lord, to supplement in this fashion. In respect of the element of prejudice, it is my submission, my Lord, that the time in which this document is intended to be introduced by the state in these proceedings on its own is irregular, and the accused persons will suffer prejudice because the basis for which this application is made is to reintroduce an evidence to rebut the version of accused number 2. Accused number 2 will still come and testify if a need arises, and the state will have an opportunity to rebut the evidence that is placed under oath by accused number 2. My Lord, it is further submitted that one must look at the reasonable time, the reasons why it was not discovered timelessly. I would reiterate in my submission by saying, if an expert witness is called, firstly, to place the authenticity of the document before this honorable court, secondly, to assist the court in drawing inferences and conclusion on the recordings, it is of pivotal importance that any submission or any evidence given by the should not be given, or should be given a preference to an independent somebody who does not investigate the matter. Hence, if Sergeant Mugano has to give evidence or his view, that view cannot hold water in terms of the admissibility of such expert or of such AVL recordings. My Lord, I would submit further before I sit that a judicial discretion is also required to be exercised when this application is brought, and to the extent that its nature, the nature of this application, must not be seen to delay the proceedings of this case. The reasons for saying that is because the state had an opportunity to investigate all the necessary information, either on factual base and on technical and scientific evidence that is purported to be used before this honorable court. And my submission further, my Lord, is that it will be prudent if the court were to rule in favor of the state to recall the previous witnesses, Mr. Mapumulo and Mr. Sadike or Mr. Jonathan, so that their AVL recordings must also be brought before this court on record and must also be challenged. And furthermore, my Lord, the evidence of this witness, to the extent of canvassing the logbooks and the pocket books of the witness, may also suffice in order to corroborate the evidence in which the state intends to lead this witness. Unless there's anything that your Lordship wants me to address.
No, thank you. Mr. Mnisi?
As we have maintained on behalf of accused number 3, we don't have any submission to make. We shall abide by the decision of the court.
Okay, yes, thanks.